Good morning. Welcome to the Long Live Alternative Parties podcast. Free Press Media Press Inc. and Alternative Parties Booksellers are sponsors of this podcast. I'm Andrew Bouchard. Today I read the case Libertarian Party versus Dardenne, 595 F3D 215, Court of Appeals, 5th Circuit, 2010. Friends, what were you doing in 2010? The Libertarian Party and also the Socialist Party were fighting the good fight of ballot access. The Libertarian Party and the Socialist Party have divergent ideologies, yet they unite for a common cause. We love to see that. Have you ever voted for these parties? The Libertarian Party I voted for. The Socialist Party doesn't make the ballot in every state I'm in, so therefore I don't have that option. But shall they do that, then I'll be willing to consider voting for them. So what happened in this case? It says, quote, appellants were excluded from the Louisiana's 2008 presidential ballot because they failed to file their qualifying papers by the applicable filing deadlines. Pursuant to a Louisiana statute, the filing deadline for the Socialist Party was September 2nd, and the filing deadline for the Libertarian Party was September 5th. Because of Hurricane Gustav, the Louisiana Secretary of State, the Secretary, unilaterally allowed parties to file their qualifying papers on September 8th, 2008. Appellants did not file their papers until after the 8th of September. Because appellants failed to file their papers by September 8th, the Secretary informed appellants that they would not be placed on the Louisiana 2008 presidential ballot. Appellants then brought this suit against the Secretary, seeking, among other things, a declaratory judgment stating that the Secretary's September 8th deadline was unconstitutional. Appellants contend that the Secretary lacked the power to set a deadline different from that of the statute unilaterally. End quote. Friends, why did the Socialist Party and the Libertarian Party have different dates? We've come to other cases where they categorize the different parties and they have different requirements based on the parties. So I don't know if that was the deal here. Maybe the Libertarian Party qualified in Louisiana as a major party and the Socialist Party did not. So the Socialist Party had to file earlier. But it's a good thing, whatever the case may be, that these parties are fighting this. What do you think about this? Do you think this was legitimate of the Secretary of State to do? I imagine you don't. Since you're listening to this podcast, you likely side with alternative parties. You likely give alternative parties the benefit of the doubt. Specifically, they argue the following. It says, quote, appellants argue that their complaint was not moot because the challenge to the Secretary of State's December 8th deadline fell under the capable of repetition yet evading review exception in mootness, end quote. And then it also says, quote, appellants also argue that they were entitled to costs and fees under Rule 4D's mandatory waiver of service provision. The district court denied appellants' motion for costs and fees, finding that the Secretary is not subject to Rule 4D's mandatory waiver of service provision because he was sued in his official capacity. End quote. The phrase, capable of repetition yet evading review, is a phrase the judges in these cases use again and again. That was one standard they determined that suggests in cases like this where election law, where sometimes you can't get to court before the election passes, you still might have issues that you want to include in the future. So it's good that we have this thing, this principle of capable of repetition yet evading review. It's good that they are scrapping for those fees. A lot of people like to mention that alternative parties are strapped for cash. So therefore, they don't want to spend any more money than they need to so they can fight the good fight. Let's see their specific reasoning. It says, quote, appellants contend that their request for a declaratory judgment stating that the Secretary's conduct was unconstitutional is not moot because it falls under the capable of repetition yet evading review exception to mootness, end quote. And then they also say, quote, the allegedly unlawful governmental action in this case is the Secretary's unilateral establishment of the September 8th filing deadline. Appellants therefore must demonstrate that there is a reasonable exception that the Secretary will again unilaterally change filing deadline in the future, end quote. The court here does not find this persuasive. Our friends at the Libertarian Party and the Socialist Party here are arguing that in Louisiana there's hurricanes happening all the time, therefore it's likely in the future the hurricanes are going to affect the timing of elections and the submission of ballot access forms. So therefore, the court should decide this. But the court says that even though this is definitely the case in Louisiana, there's no evidence that the Secretary of State is going to do this type of thing again. So therefore, it is not something that could be repeated. Unfortunately, they also deny the fees and the costs to our friends. And they ultimately conclude as follows, quote, for the foregoing reasons, we affirm the district court's order, end quote. Friends, we didn't win this one, but alternative parties have shown me that you keep fighting regardless of winning or losing. You keep fighting regardless of how you fare in the battle. And that's the spirit, that's the attitude, that's the outlook we need. So friends, keep it up. Long live alternative parties. Goodbye.